Hi, good afternoon if you're on the East Coast, and good morning if you're out west. My name is Erin Lacy, and you are listening to an examination of the U.S. Department of Education's new Borrower Defense Rule, and this is actually part two. We did a 90-minute session yesterday. This is a large and complex rule package, so we broke it up into two parts. Yesterday we talked about the claims process, the borrower discharge process, and today we're going to talk about financial responsibility, triggers and reporting, and some other related issues in the rule. I am an attorney at Thompson Coburn LLP, which is a law firm based in St. Louis. We're a big law firm, several hundred attorneys, and we have offices in places like you'd expect, Chicago, D.C., Los Angeles. I'm the leader of our higher education practice, which focuses exclusively on assisting institutions of higher education with all different types of issues. Let me just start here off the top with the housekeeping script. I mentioned yesterday, I forgot to do this a couple of sessions ago, so I'm trying to get better at it. If you have any questions during the webinar, you can submit them through the Q&A widget. You'll see if you look at your dash here, there are a handful of widgets there at the bottom. You can submit those questions through the Q&A widget at the bottom of the screen, and we'll try to answer those at the end of the webinar. And if you've listened in on any of these before, you know I'll do my best to get through as many of them as I can. A copy of the slide deck is available at the resource widget there at the bottom, and I'm going to offer a shout out to my producer here. I got the slides to these guys, I'll just say less than a couple hours ago. So they were very kind to get them loaded up and make sure everything was in order. And you can download them now. They are ready. I'll also just mention there are hyperlinks throughout the presentation, and those are live links a lot of times to underlying resources or other things we're suggesting you may want to look into. So pulling down the slide deck has its uses, no doubt. You can find answers to common technical questions under the Help widget there on the screen. And finally, if you are an attorney and you're listening in at least in part for continuing legal education, the webinar is accredited in Missouri for 1.8 hours of general CLE and for an hour and a half of general CLE in California and Illinois. If you're outside of those jurisdictions, you may still be able to get credit, but you also may have to do a little extra legwork. We award CLE based on attendance for the entire 90 minutes. From the time you log in to the time you log off, you'll see occasionally some little pop-ups that you need to click just to make sure that the system knows you are engaged. And I will do my best to keep you continually engaged. A couple other things, I always say, and I mean it as truly as it can be said, we value your feedback. At the end, you'll see there will be an opportunity to provide comments and a survey. Would greatly appreciate any feedback you have to offer. We always try to make sure that every webinar is better than the last. And finally, if you happen to be listening to this on demand, because all of our webinars after we offer them get loaded up to our TCLE library on our website and available free and on demand for folks who want to listen again or weren't able to catch the webinar on the original air date. If you happen to be one of those people, just please keep in mind that laws do change. So if it's several months in particular after this webinar originally aired, you may want to make sure that nothing significant has happened in the interim. So I mentioned at the outset, I'm Erin Lacy, partner and practice leader here in the higher education practice, Thompson Coburn. If you don't know us, the higher ed practice does a lot of different things. We provide regulatory counsel, so we talk about rules like this from the U.S. Department of Education and help folks figure them out. We do the same around state authorization rules, accrediting agency laws and standards, and that covers a wide range of issues, Title IV, federal financial aid, Title IX, Clery Act, consumer information, you name it, ADA, that kind of thing. We do a lot of work with schools of all types on sort of large-scale institutional substantive changes, transactions, that could be merger and acquisition, anything along those lines, in addition to contract drafting, services agreements, policy creation, et cetera. And then we represent institutions in a lot of different types of issues, including litigation or administrative agency proceedings. The only thing here I'll highlight is in 2018, and some of you know this, I served as one of the negotiators that was charged with coming up with this rule that became final and was published in the Federal Register actually just yesterday. So I was there in D.C. for about 3 weeks and have spent a lot of time over the last 3 years thinking about this rulemaking package, probably more than any person reasonably should. I promised yesterday to the folks who were listening in that I would not repeat the entire history of the bar defense rule, and I'm going to keep that promise. If you would like more detail regarding sort of the background and where the bar defense rulemaking started and how it's progressed, then I invite you to pull up that webinar that we offered just yesterday. Again, it's now on demand, and listen to the first 10 minutes or so. I do want to offer a little bit of context for those who may not have listened in yesterday. The first thing I want to emphasize is that the borrower defense rulemaking, or the rulemaking package, we often refer to using that term borrower defense, although interestingly enough, the administration in promulgating its final rule has sort of renamed this rulemaking package and is actually calling it the institutional accountability rule. I'm just going to keep calling it borrower defense because that's what it is in my mind and forever will be. But the rule has parts beyond just the borrower defense claim framework that we discussed yesterday. It also makes fairly significant changes to the financial responsibility regulations and some smaller but material revisions to the closed school discharge and false certification discharge regulations. And finally, it addresses the use of pre-dispute arbitration agreements and class action waivers in agreements with students. And I've said this many, many times, and I expect all the folks on the phone know it, so I am, as they say, preaching to the choir. But all of this rule applies to all institutions of higher education. Now, there are small elements here and there that will only impact schools in one sector or another. The arbitration, pre-dispute arbitration, class action waiver provisions largely impact career schools in those institutions that have enrollment agreements, I would say disproportionately. But the claim framework, the financial responsibility provisions, and the closed school and false certification discharge provisions really apply equally to all institutions, almost without caveat. So it is important, whatever institutional type you might represent, that you pay attention to these rules and give them some thought and consider whether or not there are things you need to be doing to take them into account. I did include in this presentation, in these slides, the BDR timeline. Again, I'm not going to go through all of this, but it starts all the way back in '94 when the first borrower defense rule was promulgated and moves all the way up through July 1, 2020 of next year when we expect BDR 3 to become effective. I'll also just note, for purposes of this presentation, right, when I say BDR 1, I'm referring to the first version of the borrower defense rule that came along back in '94. When I say BDR 2, I'm referring to the version of the borrower defense rule and all its various pieces, including around financial responsibility and loan discharges, the version that was promulgated by the prior administration in 2016, the Obama administration. And when I say BDR 3, I'm referring to the rule package that became or was promulgated in final form in the Federal Register yesterday and will become effective on July 1st, 2020. So again, there's sort of three generations or iterations of this rule, and it's important to understand that because of the approach this administration has taken to the rulemaking. They have not just, or will not, as of July 1 next year, eradicate the prior versions of the rule. Rather, in many instances, they have chosen to create a new set of standards that will apply after July 1, 2020, but to allow the standards that are in place currently to continue to apply to certain types of situations that precede July 1, 2020. So it's really important to appreciate that idea of there being multiple versions of this rule, and that they will, even after July 1, 2020, you'll have various different iterations of the rule that will continue to be on the books and apply in different circumstances. Okay. What is the status quo? So on October 12, 2018, BDR 2, remember that's the one promulgated by the prior administration, became the law of the land. And not only did it become the law of the land on October 12th, but it was deemed to have been the law of the land since July 1st, 2017, when it was originally supposed to be put into place. So that's really important. So BDR 2, as of October 12th, BDR 2 was deemed to be effective from July 1, 2017 forward. On March 15th, 2019, the current administration affirmed that fact. Said, yes, there was sort of this long period of silence where we were all kind of wondering what was going on. And then they officially said, yes, we acknowledge BDR 2 is now the law of the land. And they gave or put out a fairly significant amount of guidance regarding how institutions should go about then complying with BDR 2, both on a go-forward basis and sort of retroactively, since it was now considered to have been in effect from July 1, 2017 forward. The department put out a smaller amount, but also in some cases significant amount of guidance on June 3rd, and then later on June 19th, actually. And on that prior slide, I mentioned at the outset of the presentation, there are hyperlinks. There are hyperlinks to this guidance and these events. Finally, yesterday, September 23rd, 2019, the department published the official version and the final version of its new bar defense rule, BDR3, which will become effective July 1st, 2020. So when we talk about the status quo, BDR2, as of this moment in time, BDR2 has been in effect since July 1, 2017, and will be in effect through July 1st, 2020, right? So you've got a period there of about 3 years where that rule, or exactly 3 years, where that rule will be deemed, BDR2 will be deemed to be in effect. And we will expect, as of July 1, 2020 next year, for BDR3 to become effective. And to sort of set into place the framework that we're going to discuss today. Okay. So with that having been said, let's jump into the financial responsibility triggers and reporting element of this rule. And I'm going to start with BDR2. And you say, well, Erin, why are you starting with BDR2? Isn't this whole session about the new rule? Yes, but as I just mentioned, BDR2 is in place now and will remain in place until July 1 of next year. So, you've got another 9 months where you need to be complying with this rule. The other thing is the new rule built upon the framework that was created by BDR2, at least in the context of financial responsibility. So understanding how BDR2 works and how it was set up will make it easier then to understand the changes and modifications that have been made by BDR3. But again, at the highest level, they look a lot alike, right, in some ways structurally. So starting with BDR2 not only will help you understand your current obligations that you need to be aware of, but it also sets the stage for the BDR3 framework that sort of sits on top of it with notable revisions. Okay, so BDR2 financial responsibility. I already mentioned it's in place until July 1, 2020. It introduced, BDR2 did back in 2016, to the financial responsibility framework, sort of two sets of revisions. It created these financial responsibility triggers, and it put into place associated reporting requirements, right? BDR3 will replace BDR2, effective July 1, 2020, with new triggers and new reporting requirements, but it's still using that framework, right, of triggers and reporting requirements, and those will apply on a go-forward basis. So when we talk about sort of financial responsibility at BDR2 and now BDR3, I think it's helpful to take a step back, okay? The department has long had a financial responsibility framework in place, right? There are two things fundamentally that an institution has to establish to participate in Title IV programs. One is that it's financially responsible, and the other is that it has A and two. A is that it's financially responsible, and two is that it is administratively capable. So financial responsibility, administrative capability, okay? And for a very long time, this idea of financial responsibility, which is in statute and then fleshed out more in the regulations, it's had sort of some major components to it. You have to have a passing composite score. And I assume just about everybody on the line knows what a composite score is and has dealt with it once or twice before. You have to have sufficient cash reserves, right? Formally, I'm going to skip over the one in the middle, you had to be clear of any past performance issues, and you had to have a clean audit. And then there was this other category that in the old days was sort of smaller and leaner. And the big development that came along at BDR2 is the department inserted into this overall financial responsibility framework this new concept of being able to meet financial obligations and provide administrative resources. Now, what's interesting is this actually aligns more closely with the statutory language. So what was in place prior to BDR2 departed a little bit from the statutory language, and the Obama administration said, you know what, we think we should reflect in regulation the statutory language, and it talks about this notion of meeting financial obligations and providing administrative resources. So in regulation, we're going to create a new category. To be financially responsible, you have to hit it out of the park on all five of these things. And one of them is this new concept of financial obligations and administrative resources. And then they said, and now we're going to tell you what that means. So it means you have to, in order to satisfy this obligation, it means, among other things, that an institution cannot be subject to one or more triggering events if they occurred after July 1, 2017, right? So just again, to set the stage here, what the department did is they said everybody has to be financially responsible. And we have these traditional buckets of things, you know, these concepts, these standards that have to be satisfied to be financially responsible. So we're going to introduce a new standard, a new bucket, so to speak, and then we're going to lay out a bunch of various actions or events that, if they occur, you would not meet this standard, right? And the way we're going to know if they occur is you're going to tell us. So we're going to have associated reporting requirements. Okay. So BDR2 created 3 classes of triggering events, right? So again, if they said if you have a triggering event, you may not be financially responsible under this new standard. And then we're going to create classes of triggering events. We have automatic triggering events. So these are things that happen, and if they happen, we're going to recalculate a composite score, right? So you have these automatic triggering events for which a projected composite score would be calculated and used as the basis for financial responsibility determination. Then we got a second category of automatic triggering events, which upon their occurrence would automatically result in the finding of failed financial responsibility, right? So in these cases, the way the first category worked, if you had one of these triggering events, and remember, this is the law that's in place right now. If you have one of these triggering events, then the department automatically recalculates a composite score for you. And they're really using that recalculated composite score to determine materiality. Is this triggering event really an issue or not? And then you've got this middle category where if one of these things occurs, we're not going to recalculate the composite score. The sheer fact that it has occurred means you have failed financial responsibility. And then they've got this third sort of scary category of discretionary triggering events. And they say, and then we got all these other things. It's a little bit of a catch-all. And they name several different things, and they say if one of these happens, we may determine that you lack financial responsibility if we think that this event having occurred is likely to have an MAE, or materially adverse effect, on the institution. A material adverse effect is a pretty big deal, right? That's like something that would happen and be an existential threat to the institution itself. So it has to be a pretty big deal. So here on the board, and the color schemes, by the way, let me just go back. So remember, our first category where you get a new projected composite score, that's gray. And then in the middle, the stuff that you're automatically no longer financially responsible, that's in the sort of brown color. And then the purple is the discretionary events. So here's the board. All of the stuff in gray, these are events, triggering events, again, that would prompt a recalculation of the composite score. And some of these are going out of vogue, like at-risk GE programs you see on the second category, right? A lot of this stuff has created a ton of heartburn for institutions, particularly the first 2 boxes around judgments and settlements, and actually the first 3 boxes, agency litigation, and especially other qualifying litigation. So we did a webinar earlier this year, I'll reference it here on the next slide, I think, where we talked about like all these obligations around reporting litigation, reporting judgments and settlements, and some of you on the line are very familiar with the headaches that these things have caused. Well, this is how it comes into play, right? It's all part of this financial responsibility framework. You've also got the 3 in gold, or brown, 90-10 failure, publicly traded institution triggers, which are some triggers that are very specific to publicly traded institutions, failing court default rates. And then there are those 8 discretionary factors or events I talked about. I'm not going to go through all of them in detail. What I will offer is if you want more information about the current law, BDR2, and specifically what the reportable events are, the triggering events, and when you have to report them and everything, we have a guide we put out. You can click on this link and that guide will come up for you, and you're very welcome to download that. If you have questions about that, you can give me a holler. We also did, again, a webinar that is on demand. So if you want to go back and watch it, you can hold the guide in your hand and you can watch the webinar, and it goes through these reporting obligations. The only thing I would say is when we did the webinar, the June 3rd and June 19th guidance had not yet come out. So the other thing you'll want to do is click back to the second slide on the BDR timeline where we have a link to that guidance and pull that up and read it too. Right, but we've got plenty of information for you here, the guide, the webinar, and the links that can get you set on BDR2. And again, it is the law of the land right now, and it's important that you continue to comply with it. Okay, but let's talk about BDR3 then, and how it's going to change things, and how it's not. Right. So the first thing is again, this administration in promulgating the new rule has not departed entirely from the BDR2 financial responsibility framework. You know, this idea of triggers and reporting obligations is still out there. So Once again, you've got sort of the overall financial responsibility framework, and you have the stuff in gray, which has been there for a long time, and you have this new concept, relatively new, introduced by the prior administration of institutions having to, quote, meet financial obligations and provide administrative resources. But the department has changed the concept just a little bit here, and I'm going to read this second line over to the right. It says, an institution may not satisfy this standard if it fails to make timely refunds or repayments to the department. So that might be refunds to students, repayments to the department, it could be R2T4 or liabilities owed under a program review or an audit, right? Or is subject to one or more triggering events. So they've added a couple of new things in here that have always been around in the law in different places, but they've made it really clear in the context of the financial responsibility framework now that if you're not making refunds or you're not processing R2T4s timely, you can be deemed to not be meeting financial obligations and provide administrative resources under the overall financial responsibility framework. And they kept this triggering events concept, right? So that construct still remains, but they have changed it up a little bit. So remember, previously we had these ideas, we had 3 categories, and here in BDR3, the department maintains those 3 categories, but they've been modified slightly, right? And in a sense, because the modifications are slight, it's almost harder to understand, right? It'd be a little easier to wrap the brain around it, I think, if it were just totally different. But because it's the same, you got to pay a little more attention to the details, right? So the first category now, under the law that will go into effect July 1, 2020, right, will be mandatory triggering events for which a projected composite score would be calculated, right? So instead of automatic, sort of they're using this concept of mandatory triggering events. It's in the same place in the law. They're going to revise that section, so it's going to be in the same place. Then in this middle category, you have another set of mandatory triggering events, but they're for publicly traded institutions only. And upon their occurrence, there would be an automatic finding of no financial responsibility. Now, that's if you get to a final determination that this thing occurred, right? And I'll talk about that in a minute, the process. But the idea here is there's no recalculated composite score. So if you have a triggering event in Category 1, you have a recalculated composite score. If you have a triggering event in the middle category, and these events only apply for publicly traded institutions, there is no recalculated composite score, right? And then finally, you still got discretionary triggering events that the department may determine would have a material adverse effect on the institution's financial responsibility. Okay, but here's the big change, right? Oh, wait, actually there's one other thing I want to reference first. Before the big change, I stole a little month under there, but this is important. There's also this, what I'm calling the double discretionary rule, trademark pending. An institution is not financially responsible if, since the end of the fiscal year, for which the department has most recently calculated its composite score. And by the way, just taking a step back, that's the whole basis for the triggers, right? The problem was the department, particularly on the heels of some of the big school collapses, but even more generally, felt like we don't have information between one audit and the next that we need to know if schools are really doing okay. Because you can have events that occur between audit cycles, right, that are material to the institution. The problem is if we're only hearing from schools once a year and seeing those financials once a year, some intervening event may significantly damage the school's financial wherewithal, and we won't know. And now the school's going to be at risk, and we haven't taken any steps to protect students or taxpayers, et cetera. So the whole idea here of introducing these triggers is really to try to elicit or require the reporting of information between audits that the department then take into consideration, right? So we're talking about here on the double discretionary rule, if since the end of the fiscal year for which the department has most recently calculated a composite score. So they got your last audit, you turned it in for FY18, and they've calculated your composite score. Since that point in time, since the end of 18, your FY18, if you're subject to 2 or more discretionary triggering events, then it would be considered a mandatory trigger, right? So it's sort of odd, but they're saying, you know, if you have just one discretionary event in that time period, then we're going to look at it and we're just going to think about whether or not it constitutes a material adverse effect for the institution. But if you have 2 discretionary events that occur in that same time period, then we're going to treat it like a mandatory event. Now, I don't think that means they're going to recalculate your composite score. They don't say that in the regulation. I'm not sure that would always make sense. But what it does mean is they're going to treat it as if it's sort of come up out of the may find you financially irresponsible, and instead they're going to say, if you've got two, we're going to presume that you lack financial responsibility, and then we're going to have a conversation, right? So that's the double discretionary rule. Here's the big change, though, and this is what I alluded to a second ago. I just got ahead of myself. So you remember a moment ago when I showed you under BDR2 the checkerboard there with all the different triggering events, right? We'll look at it now. I mean, it's from 10 or 11. It's essentially down to 4, okay? So in that first category, the gray category for this presentation of triggering events that would be mandatory, right, and prompt the recalculation of a composite score, you only have 2 items: select judgments and settlements, and a qualifying withdrawal of an owner's equity. I'm going to go through these in more detail in a second. But at the higher level, the important note is there's just 2. And then for that middle category, remember, it's just, and these are sort of mandatory events, so we're going to presume you lack financial responsibility, but there's no recalculation of the composite score. We consider these events material just by virtue of their happening. There's just that one box of things that happen to publicly traded institutions, right? And then finally, there's still a category of discretionary factors and events, but it's down from, I think it was 9 under BDR2 to 6. So the number of triggering events has been reduced, and that means your related reporting requirements and obligations are going to be reduced, in some cases, I think, in very material ways. Philosophically, when we were at the table negotiating the bar defense rule, I mean, the department's justification here, they understood that it's sort of a slippery slope if you start asking schools to report on threats as opposed to events that have a quantifiable impact on your financial wherewithal. And what I mean by that. So remember under BDR2, I mean, you have to report all litigation without regard to materiality. So you've got a private nonprofit institution with a $500 million endowment that has to report a $1,000 settlement. That's the slippery slope, right? I mean, and of course, the folks who advocate for that say, well, yeah, but we don't have any way, we don't want to try to qualify it. We just want to see everything, and we'll decide if it's material or not. But I think the department, this administration has said, look, trying to assess potential threats like claims that have been filed, or whether that's litigation or arbitration or a bar defense claim or what have you, when it's not quantifiable yet, when there's actually no liability that's been assessed, it's premature. And we're not going to ask institutions to report on claims and threats, but we are going to ask them still to report on quantifiable events like settlements and judgments. So you got a final judgment or a settlement, and that's a real dollar amount that the institution's having to pay out. So that is going to affect their bottom line, maybe not in a material way, but it's a payout. It's not just a threat of a payout. And so the department wants to know about it. Similarly, when you got a withdrawal of owner's equity, there's real dollars there. The departure is on publicly the traded institution triggers and the discretionary factors. I mean, some of those are still sort of threat-based, but what the department has done here is they have eliminated, meaning the current administration has eliminated a lot of the reportable events that were again, just threats and had not yet actually matured into real liabilities. Okay, so let's go through these because I know some of the folks on the phone are dealing right now with the BDR2 framework and having to do all that litigation reporting and figure out, should I report this settlement or that settlement? So the good news is you're going to get to eliminate a lot of those obligations come July 1, 2020. So when BDR3 goes into effect, right, the one thing, sort of litigation-based, that you still have to report is select judgments and settlements. By the way, footnote here, and I know lawyers are fond of footnotes and caveats, but I just want to remind that we're just talking about the reporting obligations under the financial responsibility framework. Remember, there are, under BDR2, some additional obligations to report, at least for now, if you have a bar defense style claim, to actually supply judicial or arbitral records to the department. We're not talking about that right now. We're just talking about financial responsibility reporting, right? So under the financial responsibility framework, for BDR3, you no longer have to report all other qualifying litigation. You don't have to report every type of settlement or it's limited. So the mandatory triggering event, what you have to report is if you incur liability from a settlement, final judgment, or final determination arising from an administrative or judicial action or proceeding initiated by a federal or state entity. Okay, so private parties have been taken off the table entirely, right? I have a lot of schools calling me right now. We're having all these conversations around what's a settlement agreement. You know, if I have a settlement agreement with a faculty member or to settle a student complaint, if some private party threatened litigation and we settled before we even entered litigation, is that all of that gets taken off the table, right? Once BDR3 goes into effect, you're only talking about reporting liabilities from a settlement, final judgment, or final determination that arise from an administrative or judicial action that was initiated by a federal or state entity, no private parties. The reporting time frame, you notify the department within 10 days after the date of a written notification to the school of the final judgment or final determination. And the department has added a judgment or determination becomes final when the institution does not appeal or when the judgment or determination is not subject to further appeal. So this should allow institutions of higher education, and I know some of the big public entities that have really been struggling with all the litigation that they've had to report, and some large private nonprofits, those of you with hospitals and affiliated or related operations that may be captured by this rule and are subject to a higher amount of litigation than the average school, are probably are expressing a sigh of relief, because you're going to get to ditch a lot of that reporting headache right now that you're dealing with under BDR2. What about withdrawal of equity? So this doesn't even apply to private, nonprofit, and public institutions, right? So you only have two categories of triggering events now that prompt a recalculation of the composite score. Only one of them applies to private nonprofits. And I said, and publics, the law still does not clearly exclude for publics a reporting obligation, but because publics have their financial responsibility determined differently and not through the composite score, it's fair to say in a sense that neither one of these apply to public institutions. But this is just for proprietary institutions. I'm not going to go through all this in detail. A very similar concept exists in BDR2. The idea is if you're a proprietary institution and you have a composite score that's less than 1.5 on the books for the last time your composite score was calculated, and you have a withdrawal of owner's equity, then you need to pay attention, right? And this approach under BDR3 is actually a little more sophisticated than under BDR2, because the department is drawing a distinction among different kinds of withdrawals of equity. So they talk about the reporting time frame, breaks it apart, and depends on whether it's a capital distribution of dividends, or related party receivable. So my advice to any proprietary institutions on the line is, if you find on the other side of July 1, 2020, if you've got a composite score of less than 1.5 and you're thinking about some sort of withdrawal of equity, before you do that, you need to look hard at this regulation and make sure you've worked through it. And there are, by the way, and the law specifically carves out, for example, for the payment of tax liabilities, appropriate withdrawals of equity. But again, you're just going to want to make sure that you're thinking through this, and anything you're doing in a very deliberate way. For publicly traded institutions, these mirror actually a lot of what was under BDR2 with some slight revisions. So going forward after July 1, 2020, you have to report to the department if you're a publicly traded school, if the SEC suspends or revokes your registration of your securities or the entity, if it notifies you that you're not in compliance with listing requirements, and as a consequence, the securities are delisted. And by the way, the department's very explicit in the reg. I don't have it reflected here, but if you get a notification and your securities are subsequently delisted, whether it's voluntary or involuntary, that's a trigger. So, if you decide as an institution or a company to delist as a result of getting that notification, you would still be captured here, right? You don't avoid it, say, by voluntarily delisting before you might have been involuntarily delisted. And finally, if the SEC is not in timely receipt of a required report and did not issue an extension to file the report. If one of these things happen, you have to notify the department within 10 days. Now I want to talk about, these are the discretionaries. And these are important. And by the way, if you're on the line and you're a public institution or a private nonprofit and you checked out for a minute, check back in. Because some of these discretionary events could occur at any type of institution. And the first one is a creditor action. So again, this is a discretionary triggering event. If your crediting agency issues you an order such as a show cause order or similar action that, if not satisfied, could result in the withdrawal, revocation, or suspension of accreditation. Well, first of all, let's be clear. anytime you get a show cause order or anything like a show cause order, it is theoretically possible that if you don't resolve it, it could result in the withdrawal, revocation, or suspension of your institutional accreditation. That's how show cause and similar actions work. So it's hard for me to imagine a situation where you would get an order, a show cause order or something similar, and not satisfy this triggering event, right? And there are a lot of institutions out there, particularly right now with the contraction that's happening and some of the schools that are experiencing some financial distress that are dealing with show cause orders. So this is going to be a triggering event for you. And by the way, I mean, that's why the department has included it, because they know that there are things like this occurring out in the space, and they want to have a better and more timely understanding if institutions are struggling financially. And if the accreditor knows before the department, this is the way that they're going to find out. You have to tell the department within 10 days after the date on which you get that notice from your accreditor, right? So you get the letter that says we're putting you on show cause. You got 10 days to tell the U.S. Department of Education. And by the way, and I'm going to get into this again in a minute, we're going to talk about process, we're going to talk about material adverse effect. Just because, but I'll say it now, just because one of these events occurs does not mean, remember, particularly the discretionary events, does not mean that you are automatically determined to be lacking financial responsibility and you have to, immediately post a letter of credit, go on provisional or something like that. What it means is the department's going to have a conversation with you, right? And if it's, one of the first two items, they're going to recalculate your composite score. If you're a publicly traded entity, they're going to assume you're lacking financial responsibility and you're going to have to demonstrate otherwise. Or if it's one of these discretionary events, they're going to say, you need to help us understand why this doesn't represent a material adverse effect to the institution. But it doesn't mean that if one of these happens and you report it, you automatically get a letter. You lack financial responsibility, you owe us a letter of credit. You got 10 days. I mean, it doesn't work that way, and I want to be real clear about that. So these are all events you want to be aware of, because after July 1, 2020, they do still implicate potentially your financial responsibility, but there will be an opportunity for you to have a conversation with the department, and that was one of the things when we were at the negotiating table we were really adamant about. We said, look, we understand that the department needs more information, and we appreciate the department's desire to know if some of these events are occurring, but we also think it's extremely important that institutions have an opportunity to dialogue with the department and provide context. And one of the things I'm personally very pleased with, the department heard that message, and this rule provides additional, in my mind, additional procedural protections and safeguards for institutions so that they can have those conversations with the department before any final decisions are reached or actions are taken. Okay, so the second discretionary triggering event, if you violate a loan agreement. And this is a pretty sophisticated provision too, so if you think you might be getting here, you should definitely look a little more closely at the regulatory language. I try not to paraphrase when I can, but obviously I'm not including the entire Federal Register in these slides, so be sure if you think you're potentially subject to one of these events that you're doing a little more homework, or call a guy like me or your attorney and just try to wrap your head around the details. So if the institution violated a provision or requirement in any security or loan agreement, and I'm going to skip down to this next gold, and a monetary, non-monetary default or delinquency event occurs, right? And then as a consequence, I'll paraphrase, as a consequence, that creditor is able to in some way penalize the institution, impose on you collateral requirements, interest rates, or other sanctions or penalties. So boiling this down into layman's terms, the idea is, if you violate a loan agreement and as a consequence, it gives the creditor leverage to place some sort of sanction or penalty or fee on you, the department wants to know. That's a triggering event, right? And you've got 10 days to let them know after the loan violation occurs, the creditor waives the violation or the creditor imposes sanctions or penalties. So again, if you're going to violate some sort of lending agreement, you want to make sure that you are aware of these requirements and that you're prepared to report to the department. The other thing is, just a piece of side of advice, we work periodically with institutions on financing arrangements, as you would expect. And one of the things, particularly in light of some of these heightened requirements with the department and other regulators in recent years, we've encouraged schools, don't include covenants in your loan agreements that you think you're going to break, or you think it's unlikely the institution will be able to meet. And that, it sounds, to some, that may sound crazy. To others, they won't be surprised to hear me say that. But what happens is, schools occasionally, particularly in the old days, institutions would include enrollment projections or performance metrics in their loan agreements. And sometimes they were kind of wishful thinking, and everybody knew they were wishful thinking, even at the time the financing was put into place and the agreement was signed. And, our point now is, look, just keep in mind, if you're putting wishful thinking into one of these, with the result that it's going to get violated because the school can't hit the benchmark, their growth or whatever isn't going to get there, now you're going to have reporting obligations, and you're going to have to start having a conversation with the U.S. Department of Education. So, you just want to be mindful that of the covenants and various other provisions you're including in these agreements. State action. So if the institution's state licensing or authorizing agency, and you've all got them, every type of institution of higher education, except maybe I'll say the one, again, lawyers, there's always a footnote, except I will acknowledge, some of you may have charters. So there's a small percentage of institutions that are old enough that they're actually chartered. But most of us are licensed, right? And even those with charters, if you're operating in other jurisdictions, some of those other states have agencies that are licensing you, right? So if a state licensing or authorizing agency notifies the school that it has violated a state licensing or authorizing agency requirement, and the agency intends to withdraw or terminate the licensure authorization if the school does not take steps to come into compliance, that's a triggering event. This is another one that's a little squishy, right? Because on the one hand, it seems like they've added a materiality threshold here. Well, I don't have to report. If it's a routine audit, the state comes out, they walk, around the school or something, and they say, oh, and here's, 3 recommendations and 1 finding. I don't have to report that because it's not material. The problem is sometimes state agencies, these organizations have sort of boilerplate, right? And they'll say, yeah, we got 1 finding, and by the way, if you fail to resolve any of these findings, that it could result in loss of authorization, et cetera, et cetera. And I think schools are going to have to figure out how to navigate that, right? Because if you're a little too much of a textualist, or a literalist, however you want to think of it, you might say, well, it's a small finding, but if we fail to resolve it, theoretically, it could result in the loss of licensure authorization because we're out of compliance. And you're going to have to decide whether or not you think that's something you want to report. You have to talk about that with your compliance counsel or your attorneys. Notify the department within 10 days after the date on which the institution receives the notice. 90-10 rule, just for the proprietary schools. The reporting requirement actually is already on the books at 668-28C3. So you already have 45 days after the end of the fiscal year to let the department know if you violated this 90-10 rule, which the proprietary schools will know means, this is the restriction on it's really a restriction on Title IV revenue, a requirement that you have at least 10% of your overall revenue be non-Title IV. So that is a discretionary triggering event, and that was formerly under BDR2. It's in that category of automatic triggering events, and here it's been moved to discretionary, but it's still out there. High dropout rates. So this is one that was in BDR2, and the department has left it in for BDR3, but we don't know what this means yet, right? So it literally says, as calculated by the department, the institution has high annual dropout rates. We assume that's a withdrawal rate, but we don't know. There's no metric in federal law right now that's being tied to this, so we'll have to see what the department comes up with or what a subsequent administration comes up with. Because remember, even though these rules have been crafted by this administration, they can be interpreted and implemented in a different way by a subsequent administration. So, we'll see if this administration comes up with a dropout rate concept, what they think thresholds that are appropriate are, whether that's program by program. There are a lot of folks on the Hill right now dealing with the HEA reauthorization who feel like we should be looking at things and metrics at the program level and not at the institutional level. It would be interesting to see if the dropout rate metric was a program-based metric, and then whether it's, graduated or based on the length of time the program's been in existence, whether it varies based on type of institution or type of program, et cetera. So I think that's a complicated endeavor. We'll see what comes of it. And right now there is no obligation specified for reporting in the law. Similarly, CDR rates. So this is a discretionary triggering event if the department has high cohort default rates. And there's some language here, if it's on appeal or you're challenging it, it's not yet a triggering event, so you may not yet have to report it. Although there's no specific reporting time frame here either. I assume that is because the department already knows, right? I mean, you're already reporting CDR's information to them. They've got that data. If you're appealing, they know that as well. So in this case, they may not need you to report to them, though they still want you to report 9010, even though they have that information as well. So it's sort of interesting where they've decided not to include reporting requirements and where there are some in place. So let's talk about process. I mentioned this earlier, and this was one of the things we talked about. You know, we acknowledged, again, at the negotiated rulemaking table that the department was probably you know, not just within its authority, but thinking correctly to say, you know, we in some cases need more information, or we want to know about certain types of events. So there wasn't a lot of battle over that. But what we were very concerned about was that institutions, again, have this ability to dialogue with the department and to demonstrate if an event is not material before any type of ultimate decision would be made. And so that's built into the BDR3 process. So you'd have a triggering event that would occur. And in most cases, as we just discussed, you would have to report that event to the department with a couple of exceptions, right? When you provide that notice, when you provide that initial notice to the department that a triggering event has occurred, and right now I'm going to assume that goes to an email address at the department, you know, until they tell us otherwise, because that's how the current financial responsibility triggers work. So when you provide that notice, you have an opportunity at that same point in time to give the department some idea as to why the event is not material. Certainly does not constitute a material adverse effect, et cetera, right? So if you had a settlement with an administrative agency, it qualifies as something you have to report, and it was $3,000, right? And your institution's, you know, again, endowment's $500 million. I mean, this is the time when you make that point. By the way, something I want to highlight, I mentioned earlier that on June 3rd, the department provided additional guidance regarding just a handful of questions on financial reporting. That's this administration, and they're talking about BDR2. They didn't put out a new electronic announcement. The same electronic announcement that they put out on June 3rd, there's a link that leads to a Q&A PDF. There was no new electronic announcement, but that PDF has been updated and was updated on June 19th. And there were 2 or 3 additional questions with some additional answers. And one of them, they said, was, you know, schools kept asking, is there a format or a recommended format for when you report things under the BDR2 financial responsibility framework, right? And the department in that document that was updated on June 19th says, well, there's no specific format, but here's some things we would recommend depending on different types of events that you may want to tell us. If you haven't seen that PDF, again, there's a link to it in the timeline that was earlier in this presentation, but if you haven't yet seen that PDF, I recommend that you pull it down, because not only is it helpful to know sort of the kind of information the department might like to see for the BDR2 financial reporting, but it probably previews for you at least what this administration would consider to be appropriate reporting even under BDR3, right? Okay, so getting back to the BDR3 process and consequences. Triggering event occurs. In most cases, you're going to report that, right, if it's an actual triggering qualifying event. Then you have an opportunity when you send in that notice of the event to tell the department about any mitigating circumstances, to inform them of any context that's appropriate in their materiality consideration. As applicable, the department will calculate a new composite score, right? So if it's one of those select settlements or judgments, they would do a new composite score, or if you had a withdrawal of owner's equity. Incidentally, if the recalculated composite score is less than 1, then that's sort of how they determine materiality in the context of those 2 events, right? If it's above 1, presumably the department determines it's not material, and you don't even have to have further conversation with them, right? If it's not one of the events that requires a recalculated composite score, then you essentially skip that step. And then you have another opportunity. So the first thing is the department, and this process, by the way, it's not as if it's spelled out with, you know, boxes like this in the regs, but there is reference in the regulatory language to a preliminary determination and a final determination. So that, you know, implies strongly that what will happen is the department will receive your initial notice, anything you may have provided with that initial notice, they'll project a composite score if it's appropriate, and then they'll have a preliminary determination, at which point the institution will have another opportunity to engage in some conversation with the department prior to them issuing a final determination. So let's focus for just a minute on what that final conversation between the interim or preliminary determination and final determination, what you're talking about with the department. So the regs clearly state, and this is important, that an institution will only be deemed to lack financial responsibility if the department determines that the event is likely to have a material adverse effect on the financial condition of the institution. So in some cases, as we've seen, the department measures the likelihood of an MAE based on the composite score. So if they recalculate composite score, it's below 1. That's basically their way of determining for those events whether they think there's a likelihood of material adverse effect. In other cases, like with the publicly traded institution triggers or the discretionary triggers, the double discretionary rule, right? But in those cases, that likelihood of an MAE is sort of presumed, right? So if you're a publicly traded institution and one of those events occurs, there's no recalculation of the composite score, and there's sort of a presumption that there's a likelihood of a material adverse effect. Similarly, if you have two discretionary events, there's sort of a presumption, and that's what makes those mandatory events in a sense. It's the concept there, is that there's sort of this presumption of an MAE. For discretionary triggering events, there's no formula for presumption. Really, all the department says is if one of these happens, not the double, but just one, then we're going to have to talk with the institution to see if we think there's a likelihood of an MAE, right? But the critical point is, in all three cases, whether you have a recalculated composite score, whether you're a publicly traded institution, you got a double discretionary that's happened, or just a single discretionary event that's occurred. In all cases, the regulation guarantees institutions an opportunity to address materiality, and specifically to demonstrate that an event has been resolved, that insurance covers those liabilities, or to otherwise explain or provide information that demonstrate that the triggering event has not or will not have a material adverse effect. So you get a chance. And that was the critical thing that we were really pushing for in the context of the neg reg. The department also contemplates specifically in the regulation the submission of certain types of mitigating documentation for certain types of triggering events. Specifically, if you had a withdrawal of owner's equity, documentation showing that it was used exclusively to meet tax liabilities of the institution, and I mentioned that earlier, right? Or if you had that violation of a loan agreement, that the creditor waived the violation of the loan agreement entirely, right? So you've got, in specific instances, the regulation actually anticipates documentation that you'll be providing. So that's the financial responsibility triggering and reporting framework under BDR3, as well as some reminder around what's currently required under BDR2. And I would say that's probably puts us at about the 60% point on the presentation. I want to spend the rest of the time talking about some of the other things under financial responsibility, at least as far as composite score changes, and then also some of those other discharge mechanics that have changed a little bit around closed school loan discharge and false certification discharge. So first, composite score changes, just at a glance, there were three sort of categorical areas in my mind that I've seen this divided up differently, but in my mind, sort of three categorical areas the department addressed. The first is the treatment of operating leases and trying to accommodate and figure out how to manage changes that FASB made to accounting standards. The second is the treatment of long-term debt in the composite score. And then finally, there were a host of smaller technical changes that were made. And when I say technical, I mean maybe that's an unfair categorization or phrase to use. I mean, some of these have meaning to them, right? But they're changes that were largely made for purposes of conforming or updating terminology or definitions, or in some cases trying to clarify or require some additional information from institutions when they report their financials so that the department can more easily calculate a composite score, right? But these are all changes that I expect institutions will be able to sort, and their accountants specifically, will be able to absorb and put into place without too much heartache. What I really want to focus on is the first two, treatment of operating leases and treatment of long-term debt. So on February 25th, 2016, the Financial Accounting Standards Board, FASB, I understand that's how all the cool kids say it, issued Accounting Standards Update, ASU 2016-02, Leases, Topic 842. This is clearly a group of accountants have are responsible. I shouldn't throw stones from my glass house as an attorney, but I love the detail and how it just rolls off the tongue. So the gist of this, and by the way, I am not an accountant, and I'm trying to be very careful here about getting too far out over my skis, as they say, and I'm going to strongly recommend here at the end of this section that you should explore these topics in more depth and detail with your accountants, and also I'm going to recommend a couple other places you can look. But from the lawyer's perspective, I want to at least give you at a high level things that you should be thinking about if you're not already aware of these things. And my guess is your accountants and financial officers are plugged in, but just in case, or if you'd like to have a conversation with about them, I want to go through the core concepts here, right? So on the treatment of operating leases, the main point is FASB implemented a change, or at least resolved to implement a change back in February 2016. And they said, look, rather than disclosing these leases in the financial statement footnotes, sort of off book as they've been treated historically, operating leases are going to move to the face of the balance sheet, with right-to-use assets added to the balance sheet's assets section and lease obligations included in the liability section. So suddenly, these operating leases, which were essentially off-book, are now on-book, right? Public entities were required to implement this FASB change for fiscal year starting on or after December 15th, 2018, and they've already been working on it. Right? And private entities were required, at least when this thing initially came along, to implement the changes for fiscal year starting on or after January 1st, 2020, although earlier this year, FASB recently proposed to delay implementation for private entities, including private, nonprofit, proprietary, doesn't matter, non-public entities, to January 1st, 2021. And though that has not been finalized, it is my understanding as an outsider looking in that FASB doesn't expect, there's a comment period in play right now, they don't really expect to get any resistance. So it sounds like this delay is likely going to go into effect. And the idea is to give private entities a little more time to look at how the public entities have been managing. So the department doesn't control FASB, right, or the accounting standards. They do control the composite score, though, right? And the composite score typically follows and aligns with accounting standards, although certainly those of us who've been involved with disputes with the department would argue that that is not always the case. Sometimes the department appears to just say, you know what, we control the composite score, we can do with it what we want, right? FASB is a different organization. But here, the department and the preamble to the proposed rule last year acknowledged that, you know, this is a significant change in the FASB standards and one that can have a dramatic impact on an institution's composite score, even if the financial condition of the institution has not changed. And, you know, there were folks from NACUBO and other organizations, that's the National Association of College and University Business Officers, and other accounting and financial professionals that were part of the negotiated rulemaking. There was a subcommittee specifically put together to deal with these issues around financial responsibility and this issue, among others, dealing with the composite score. And all of those folks agreed to one extent or another that this was something that needed to be addressed. And there was at least one negotiator at the table who actually did a little research among his constituency and talked with the department. You know, there was a feeling that it could impact a composite score anywhere from sort of 0.1 to 0.4, right? So you might go theoretically from having a 1.8 to 1.4, and your financial condition hasn't changed at all. It's just based on the difference in how you're accounting for your operating leases. So it's a concern. And what the department has done is they've come back in BDR3. They've added around several ideas. They had sort of a different approach originally proposed in the proposed rule last year. And what they've come out here is they said, look, we're just going to calculate a single composite score. Okay, but what we're going to do is we're going to introduce this bifurcated approach. And so we're going to treat leases one way if the lease was entered into, a certain point in time, and treat leases a different way if it was entered into at a different point in time. Rather than being so vague, why don't I just put a slide up? So specifically, for leases entered into before December 15th, 2018, for composite score purposes, the department will continue to treat those leases as they've been historically treated, right? With the understanding that the department is going to require a school to provide information about the leases and FASB implementation and other things in the notes. If the lease was entered into on or after December 15th, 2018, then the composite score calculation, when the department does it, it's going to treat those leases essentially as required under FASB. Now, I will note there was some question that arose as to whether or not, well, does that mean after December 5th, if we entered into the lease after December 15, 2018, the department's going to treat it as if it was subject to the new FASB standards, even if FASB has actually delayed the implementation of their standard to January 2021. I don't think that's the department's intention. I think the department is aware that there might be some vagary in the way the regulatory language is written, and I think you'll see guidance. What I think it really means is they're saying, look, if you enter into the lease before December 15th, 2018, right, then we're going to ask for a little additional information, but for the most part, the expectation is it'll still be off book, right? If you entered into the lease on or after December 15th, 2018, to the extent that that lease is subject to the new FASB rule, so when the new FASB rule goes into place, then we would treat the lease appropriately under the new FASB rule, right? So you'll want to look for the additional guidance from the department, but the main thing to take away from this is the department is trying to accommodate this change, and they're essentially grandfathering in leases that were entered into before December 15, 2018, and you'll be able to continue treating those even on a go-forward basis as off-book, as if they were under the old FASB standards. One thing I do want to note, the second bullet here on the bottom, the exercise of options to extend the grandfather leases will be considered as new leases for composite score purposes. So my understanding of what that means is, and you can check with your accountant, but it looks to me that that means if you re-up a lease, it's going to be considered as if it's new and was entered into after December 15th. 2018. That's, again, something you'll want to run to ground, and you want to look for any clarifying guidance from the department. So let's talk about the treatment of long-term debt in the composite score. So this administration, by the way, has sort of been tinkering with the composite score. Behind the scenes, I mean, I've been involved in some appeals relating to determinations they've made in the last 2 or 3 years. And, you know, it's interesting because I think there was sort of this feeling that this administration would be a little more or a little less interested potentially in the composite score than the prior administration. And that just has not been the case, as seen by the fact that they worked it into this rulemaking. And by the way, important note, neither of these topics, neither the FASB update, and that's understandable because it really hadn't occurred yet, but nor the treatment of long-term debt in the composite score was addressed in BDR2. In other words, the prior administration really did not get into these issues. This is something that the current administration has spearheaded. And as they made clear in the preamble to the proposed rule and reiterate here, it is their view that using long-term debt that is not clearly attached to PP&E, right, is inappropriate and can be used in a way that, in their view, manipulates the composite score. And manipulates is a term that they use, okay? And a lot of institutions, proprietary, private nonprofit, for years have used long-term debt. And in that way, I mean, they might have had a line of credit or something that they would infuse into the institution for some period to help manage and improve their composite score for the year. And the reason schools were doing this is because back in 2003, July of 2003, there was a Dear Colleague letter that came out and expressly permitted the primary reserve ratio, which is part of the composite score, to include all long-term debt attained for the institution's purposes up to the institution's total net PP&E. Right, so you could have that line of credit, and that was expressly permitted under this Dear Colleague. So in the final rule that was published yesterday in the Federal Register, the department clearly and expressly states that the regulations BDR3 are repealing that Dear Colleague. And they say, and this is a quote out of the Federal Register, and I've got the site down there for you, we're grandfathering in existing long-term debt as reported under the Dear Colleague. Right, so if you've already got that long-term debt on the books, we're going to grandfather it in. But new long-term debt has to be associated with and used for PP&E, and that's new long-term debt after July 1, 2020, right, when this rule becomes effective. Putting a slightly finer point on it, the department says, if an institution, this is from the Federal Register, if an institution wishes to include debt, including debt obtained through long-term lines of credit and total debt obtained for long-term purposes, the institution must include a disclosure in the financial statements that the debt, including lines of credit, exceeds 12 months and was used to fund capitalized assets. In other words, PP&E or capitalized expenditures per GAAP. By the way, so this language is out of the Federal Register, and that's where you'll find this. A lot of these changes are actually in the appendices A and B to Subpart L. So appendices A is proprietary schools, B is nonprofits. And Subpart L breaks down the reporting of the composite score, right? So you have all these charts. Some of you who do this kind of work will remember it's sort of an odd spot in the regulation where you've got, it looks like photocopies that have made too many times and really tiny text that can be kind of hard to read. But that's where these updates went in. There are little asterisks that appear in those charts showing you how to calculate the composite score, and what they've done is they updated some of that language around what's allowable when putting together the composite score. There's a much more in-depth conversation around these composite score issues in the Federal Register, and you can also take a look at those charts and the footnotes that go along with them. My advice, again, I am not an accountant. I want to be very clear about that. My advice is to speak with your accountants about these changes. The folks who are calculating your composite score, the folks who are helping you make long-term decisions about operating leases, et cetera. And also, I mentioned earlier, I strongly recommend, if you have an interest in learning more about this, and your accountants and chief financial officer, either you're not an accountant or a chief financial officer, and for some reason they're not telling you about it. You can go to NACUBO, National Association for College and University Business Officers. You can follow that link, or you can click on this image, and their coverage of the bar defense rule has been superb. And as you would expect, their focus has been primarily on, not entirely, but primarily on the treatment of the composite score and some of these financial responsibility concepts, right? So it's very good. They've already did, I think on September 9th, they had a short write-up around BDR 3 based on the unofficial version of the rule that came out a couple, 3 weeks ago. I anticipate that in the coming weeks they will have a much more thorough analysis of this rule and have advice for institutions on how to think about and manage some of these changes. And while NACUBO's membership is primarily, maybe entirely, I don't recall, private, nonprofit, public institutions, representatives of those institutions, the analysis that they are doing, much is available free and on their website, and would also be of great interest and of use to proprietary institutions as well. So I encourage anyone who's interested in learning more about these topics to check out their coverage. Okay, so moving right along, I'm going to take a quick sip of water and then we can talk about closed school loan discharge. Okay, so you have bar defense discharge, and somebody yesterday was asking me about, at the end of the session, some of the questions were about, how is the department ever going to get to all these, processing these hundreds of thousands of bar defense discharge claims? Well, one of the tools that they are using, and very effectively and appropriately, is the closed school loan discharge. Because, you could have a student who says, I was wronged by my institution, but if the institution closed, it's much easier for the U.S. Department of Education, under the closed school loan discharge regulations, to just discharge their loans that way, because there's no factual question around whether or not the school closed, and that's the key qualifying element for the discharge. Whereas for bar defense discharge, there has to be this analysis depending on the claim standard that's appropriate to apply. Was there actually an act or omission? Did it violate a law, et cetera, right? So the closed school loan discharge is an easy one, for the most part, for the U.S. Department of Education to execute on, and they do regularly. In fact, you probably just saw, if you follow the news, a couple, 3 days ago, that the department approved the closed school loan discharge for, I think it was just thousands and thousands of students who were enrolled at the ITT schools at the time that they closed, right? And that's much easier than processing a bar defense claims for all those students. The other thing is when you effect a closed school loan discharge, typically the department just discharges the full loans, all of the loans that the student took out, and there's not any question around, whether they should do a partial discharge, which also comes into play under the bar defense framework. I want to be clear, I think the department has the discretion to make a partial discharge under the closed school loan discharge, but typically in my experience they just discharge everything. I will also just offer here at the outset that I'm not a great fan of the way the current closed school loan discharge regulations read. I probably was one of the folks who spent more time on this at the neg reg table than others because I mentioned earlier, higher education is going through this period of consolidation and contraction, and these closed school loan discharge procedures apply, and this is an important note. So if you're a large flagship state university right now and you're listening in, and I know we have a few, or if you're one of the private nonprofits, keep in mind these rules don't just apply if the whole school closes, right? These rules also apply if you close an additional location. So if you've got 35 additional locations in the United States and around the country, and your additional location in Taiwan is just not doing well, and for political or other reasons you decide to wind down and close that location, you still have the you're still covered by the closed school loan discharge regulation, right? So there's still exposure there, and there's a process you have to go through, and you could have students ostensibly apply for a closed school loan discharge. And one of the things I was talking about when we were at the table was it's really important when you're designing these regulations to do so in a way that encourages schools to close responsibly and to provide good services and make sure everybody has a chance to complete their education. But it is shockingly easy to put into place incentives that may be well-meaning, but inadvertently encourage schools or incentivize schools not to do that, to close rapidly, for example, or not to invest in the services students might need, or not to try to seek teach-out agreements. So I think you have to be very careful in this type of situation where you're dealing with schools that are closing, whether it's the whole school or just an additional location, and not unintentionally creating incentives that may not incentives for schools to act in ways that may not actually be at the end of the day the best thing for their students. And I can imagine folks on the other line saying, well, any school that wouldn't act in the best way for their students, but it's not that simple, right? I mean, if a school has an opportunity to close and do a teach out over 6 months or 8 months, right, both of those can be within the realm of reason, and a school may be able to carry out that teach out in either time frame in an appropriate and meaningful way, right? But you might say, well, it would be better to do the longer teach out, 8 months, but you have to be careful because you might be incentivizing them to do it in a more compressed time frame, and maybe that's not ultimately the best thing for students, though both would be reasonable, right? So there are nuances here. One of my frustrations too is the department, and I talked about this at length yesterday, the department in implementing on July 1st, 2020, implementing BDR3, has elected in many cases not to rewrite the existing rules, but instead to put in place a separate and new process. And what they've said is, if the underlying loan that the student is trying to discharge was issued before July 1, 2020, they'll use the old standards and process. And if it was issued for the first time after July 1, 2020, they'll use the new standards and process, which I think becomes very confusing because that means on a go-forward basis, at least for several years to come, you could ostensibly have students who you get two sets of students who both were at a school that closed, and one student, their loans, they have loans that were issued before July 1, 2020, and maybe some that were issued after. And another student only has them that were issued after, what have you. And now the department's going to have to apply two frameworks, even for the same student at the same closed school, to decide whether these loans should be discharged or those loans should be discharged. It just creates this complexity in the regulation that I think is a little bit frustrating. And they've done it for the claims processes under borrower defense discharge, which I talked about at length yesterday, and they've done it here for closed school loan discharge, and as we'll see in a minute, for false certification discharge. And you may say, why would they do that? Why create this sort of complexity and in some cases real likely administrative headaches trying to figure out what to apply and where? And again, I think it was because I spoke to this yesterday. I think it was political. I think it's because this administration did not want to be viewed as diminishing any rights for any students that would have existed under the current framework, right? So what they're saying is, look, anything that, whether it's today or it's a year from now, if you had a loan that was issued, July 1st, 2019, over the next 3-4 years, it doesn't matter. You'll always be able to seek the discharge under the rules that were in place in July 1, 2019, even after BDR3 goes into effect, because it's tied to when that loan was first dispersed. So you're not losing rights relative to that loan. Right? We're changing the framework, but only on a go-forward basis, right? So nobody can argue that we took something away from them that they previously would have had. And I think that was fundamentally the idea, okay? So here again, the department creates a bifurcated system. BDR3 changes the closed school loan discharge rules, but only the new rules, the BDR3 rules will only apply to loans first dispersed on or after July 1st, 2020. Loans dispersed prior to that point will still be considered under the framework, the closed school loan discharge framework in place today under BDR2. The BDR3 rule, by the way, it's a mixed bag in my opinion. I mean, it expands the discharge window from 120 to 180 days. And look, I'm gonna. This is my soapbox, and I'll only give you 30 seconds on this. But and the department's heard this from me directly. I said it openly at NEGREG. You know, my biggest, as a regulatory guy and an attorney, my biggest problem here is the statute says that a student qualifies for a loan discharge if they aren't able to complete the program because the school closes or the location closes, right? And what the department in its regulation has said is, well, we'll discharge their loan if they weren't able to complete their education because they were enrolled when the school closed, or if they were enrolled at any point 120 days before that. Now 180 days. So let me be clear. So what the department's going to do is when you wind down your location or close your location, and let's set the closed school off to the side right now. Let's just talk about a single location. Again, you got that location in Taiwan. You're ready to wind it down. On the last day when the school closes, the department's going to say, we want a list of everyone who was enrolled at any point in the prior 6 months, right? 180 days back. And anyone who's enrolled, if they withdrew during that period, they're still eligible for a closed school loan discharge. You say, well, wait a minute. I announced to my campus January 1st that we were going to wind down and teach out the rest of the programs, okay? And we did that. You know, we made sure everybody had a chance to graduate. We stayed open. We paid our instructors. There's no diminution of services. Everything was great, right? And yet now, at the end when I close, someone who withdrew 3 months ago, they can claim a closed school loan discharge and get their loans discharged, right? I think that's problematic. The other thing that's and I don't think it's consistent with the statute. The other thing that is problematic is, you know, the department says, well, if somebody transfers their credits to another school, then they aren't eligible for a closed school loan discharge. But the department acknowledged at NEGREG, because I asked this question, you know, there's no system in place to track students and whether they transfer their credits to another institution. So let me be clear. What happens functionally, operationally, when you have a school or a location that closes, is the department has a servicer, and they just send out closed school loan discharge applications to everyone who's on that list of students that you provided the department and said were enrolled at any point over the last 180 days. Right? They send those applications, and then the students write back and said, yeah, I withdrew, or, you know, whatever, I left prior to the end of school closing, I didn't graduate, or I wasn't able to graduate because the school closed, and then the department will process that discharge, right, sometimes within just a few weeks or months after the school closed. So you may not know if a student transferred yet, and some other institution accepted their credits. Right? And they've already got the discharge. And the department has no way of tracking those students or going back and saying, well, it turns out you transferred the credits and graduated from another school, so you should pay us those loans back. That system's not in place. So I think there's a lot of improvement here. There were a couple of things, though, under BDR 3 and the closed school loan discharge changes that I think are positive. And I don't mean positive. I want to be real clear, too. If a school closes or a location closes and a student's not able to complete their program, they absolutely should be eligible for a closed school loan discharge. I don't want anybody to take away that I disagree with that. My concern is where you don't have a framework in place to track whether folks really, you know, if they withdrew from some other reason, if they, you know, unrelated to the school closing, or if they were actually able to transfer their credits, you know, because those are not supposed to be reasons, or in those instances, they're not supposed to be eligible for a closed school loan discharge, right? So under the new rule, the department actually does suggest that they would exclude from eligibility for a closed school loan discharge students if they've accepted the opportunity to complete or are continuing in the program of study or a comparable program through either an institutional teach-out plan performed by the school or a teach-out agreement at another school approved by the accrediting agency and, if applicable, the state authorized agency. So this is a big deal because under current law, even if you set up a teach-out program, right, a student doesn't have to take it. So you could announce that you're closing, right, on January 1st. The next 6 months, we're going to teach, make sure everybody has a chance to graduate, or we have a partnership with the university across town, you know, and you can go there and finish your program. A student could just withdraw. They could just say, I don't want to do the teach-out, right? And then they're eligible for a closed school loan discharge under current law, which seems problematic, particularly against the statutory language. But that's what the current law provides, and that's how the department currently operates. This administration has said, look, if you provide them with that teach-out opportunity and they accept that opportunity to complete it, even if they haven't completed it, right? To be clear, if they accept that opportunity or they're continuing on, then they're not eligible for a closed school loan discharge. Now, there's still a question, what if they accept the opportunity to complete it, but then they change their mind and leave? Does that somehow reinstate their eligibility? And I think that has yet to be seen. The department also revised the exceptional circumstances under which they can actually extend back beyond a 100-day window. So it's a 180-day look back, and the department's standard protocol I mentioned earlier under this new rule is going to be to say, tell us everyone who's enrolled at any point in the last 180 days. But they can extend that look back even further. And under the current rule, it's typically if this, they've lost accreditation or state authorization or sort of a material adverse event, right? But here, this is a real head scratcher. They've included this language that says if the teach out of the student's educational program exceeds the 180-day look back period for a closed school loan discharge. I'm really not sure I understand what that means. I would think you would want institutions to announce teach outs as early as possible, because that gives students and faculty and staff as much time as possible to plan accordingly, right? But what this seems to suggest is if I decide to announce a year in advance, so let's say I'm a traditional institution and I offer bachelor's degrees and master's and doctoral programs, and I've got folks who are in 3 or 4 year programs, and including at this location I'm going to wind down, and I want to tell them a year or two in advance. And I say, we're going to start, the teach out now. Over the next 2 years, we're going to wind down, et cetera. I mean, this seems to suggest that that's an exceptional circumstance. In my mind, and this goes back to the point I was making earlier, this has just incentivized schools not to announce more than 60 days or 6 months in advance, right? Because if I let folks know a year or two in advance that I'm starting the teach out, and there's this question mark, right? Well, when does a teach out begin? I mean, how do you know how long the teach out's been going? Is it on the day I announce that it's starting? Or, it's not, even that's not clear. But under this rule, I wouldn't want to announce more than 6 months out, right? Because then the department might say, oh, well, you exceeded 180 days, so we're going to extend 180 days back for a year, and anybody who's enrolled for that entire last year is now eligible for a closed school loan discharge. This is what I'm talking about, how the incentive structures can be really tricky. And so we'll have to see what the department means by this. Finally, the automatic discharge rule that's currently on the books. So right now in the law, if you've got a school that closed, the department will automatically discharge the loan without an application from the borrower if the borrower did not subsequently enroll in any other Title IV institution within a period of 3 years. So it used to be, to get a closed school loan discharge, a borrower had to apply, right? And then the prior administration under BDR2 said no. If 3 years goes by and they haven't enrolled anywhere else and their school closed while they were still enrolled, so they were on that list and NSLDS doesn't show us that they've shown up anywhere else, then we're just going to automatically discharge their loans. Right? And a lot of folks out there know this administration started doing that consistent with this rule. And there were questions about, well, has the person really enrolled and is the NSLDS data correct, et cetera? Were they really enrolled at the time the school closed, which can be confusing sometimes depending on how your OPIDs are structured and things like that. So it was a little bit of a mess, but the department has started doing this already. Well, this administration has said, okay, so we're not going to take that right away. If you close between November 1, 2013 and July 1, 2020, over a almost 7 year span, we're still going to do the automatic closed school loan discharge, right? So let's just be clear. Even once BDR3 goes into place, anyone who, any school or location that closed between November 1, 2013 and July 1, 2020, you sent the department a list, or they have a list of individuals they think, or borrowers they think were at that school at the time the school closed or within 120 days prior, they're going to automatically discharge their loans. That's not changing. But on a go-forward basis, after July 1, 2020, for any school that closed after July 1, 2020, there will not be an automatic discharge feature. Students or borrowers will have to actually apply. Fall certification, just real quickly. The department, what's interesting is under current law, and this may surprise some of you, the way it's written, high school fall certification for issuing a loan to someone who, or certifying a loan for someone who didn't have a high school diploma or its equivalent, was sort of tricky the way the language is written. So under BDR3, the department has said very clearly, at least when you're talking about loans after July 1, 2020, so again, they sort of have this bifurcated concept, but they said, on a go-forward basis, it is a false certification if you certify a loan for a student with no high school diploma or its equivalent, right? So it doesn't doesn't turn, at least in that part of the law, it doesn't turn on whether there's a report, they reported it to you or they represent it. This way, it just says plainly, subsequent to July 1, 2020, if you certify a loan issued after July 1, 2020 to someone who didn't have a high school diploma or its equivalent, right, then that's a basis for a false certification. But then elsewhere in the reg, the department has this sort of caveat, and they say, okay, despite having said that, a borrower would not qualify for a false certification discharge if they were unable to provide the school with an official transcript or an official copy of the high school diploma and submitted to the school a written attestation under penalty of perjury that the borrower had a high school diploma. So here's my simple advice to you guys. If you require a high school diploma or its equivalent as part of admissions, which for most Title IV students you're going to have to do, right? I would include as part of your admission process, I would require an attestation from the student that they have that high school diploma under penalty of perjury so that you have this document on hand. So that if it turns out that they don't and they didn't produce it, that you aren't subject to a false certification loan discharge, right? So if you don't have some process in place right now where a student is providing that kind of attestation, you're going to want to put one in place. And the department, incidentally, has said that they're going to produce model language for written attestation for schools to use. So my advice to you is use it when it comes along, right? The other thing I'll note is a lot of people may not have realized, and this has actually been in the law for a long time, and when I have conversations with schools, sometimes they're really surprised by it. So someone also can seek a false certification or discharge of their loans if they are able to establish that they had a disqualifying condition, and that can be physical or mental condition, age, or criminal record, that precluded them from meeting state requirements for employment, right? So in other words, if you certified a loan for someone, in theory, right, and they had a criminal record, and it turns out when they graduate from your program, they can't get employed in that profession because they have that criminal record, that's a basis for a false certification discharge. And by the way, that's just what the law says, and it's said that for a very long time. The department here didn't change that law, but they say in the Federal Register, we understand that there is some concern now because there's so much pressure on schools not to ask about criminal records. Some states have outlawed it, et cetera, that you might not know. So how can you be hit for a false certification on the loan if you don't even know if they have that criminal record, right? And the department says, and I quote, if schools do not have knowledge of the disqualifying condition that precludes the student from meeting the state requirements for employment in the occupation for which the training supported by the loan was intended, then schools cannot falsely certify a student's eligibility. So in other words, the department has sort of opened up the door for schools to, say, look, we don't ask about physical or mental condition. And remember, this isn't pre-admission. This can be after admission at the time of certifying the loan. So, because otherwise you'd have an ADA issue, right? But, if a school says, well, we didn't ask about physical or mental condition either before or after admission, or age or criminal record, and the student didn't volunteer it so that you didn't know, then that's a defense against a false certification discharge claim. I'd like it better if it was in the regulation, but at least it's in print in the Federal Register for now. Finally, on pre-dispute arbitration agreements and class action waivers, I've really just got a couple of 3 slides. The main headline here is BDR3 eliminates from the direct loan participation agreement essentially the ban on the use of pre-dispute arbitration agreements or class action waivers. And instead, the department here is requiring enhanced disclosures. So they want a bunch of, if you do use a pre-dispute arbitration agreement or class action waiver, and it's a condition for enrollment or continuing enrollment, then they want you to provide some fairly significant disclosures to the student and also to provide information to the student at entrance counseling, the time of entrance counseling. And I've got a couple other slides here that I'm going to skip over that just talk about that. But here's the complexity here is not in figuring out what you've got to do on a go-forward basis in terms of disclosing to students. The complexity here is, well, what if you had an arbitration that was in place when suddenly BDR2 became effective and you had to notify your student about, or the borrower or whoever was in the arbitration, about the ban, and now the ban goes away as of July 1, 2020, I think you need to sit down with the attorneys that are helping you manage that arbitration or, class action or what have you, and talk to them about what all this means practically for the proceeding that you've got in place. That is tricky business, and you need to talk with your legal counsel about it. But in terms of on a go-forward basis on July 1, 2020, what you're going to have to do, if you're going to use these types of clauses in your enrollment agreement or any other agreement with students, then you just have to make these disclosures and make sure you're getting all of that done. So I'm just going to skip these. And then TC Resources, we've got our higher ed webinar series. Would love for you to tune in October. We're talking a little more about institutional mergers in higher education. November, I'm going to talk about probably state authorization along maybe with any updates we have on bar defense and other regs. Maybe we'll have a new Title IX rule, who knows. All the webinars are on demand. Again, you're welcome to hit them. Check out our blog, Regulation, and check out the extra credit materials like the Bar Defense Reporting Guide. We will plan the reporting guide we've got out there right now. There's a link to it. Remember earlier in the presentation, it's for BDR2. We will certainly update it when July 1, 2020 rolls around, so folks can have that new reporting guide handy on a go-forward basis. All right, we did it. Phew! 129 exactly. So let me see if I can we're not overwhelmed with questions here, just a handful. So let me see if I can get to these. I'm counting 4. To clarify, if settlements occur post-audited financials, is the requirement to recalculate the composite score for the prior audited financials, even though this would be a subsequent event after release of the audited financials? Yes, I believe that the idea is that the department would take, and there's regulatory language that gets into detail about how they would recalculate the composite score and treat certain of these events. And I didn't go over that here. That's something you'll want to talk about with your counsel or with your accountant or whoever. But they specifically talk about, I think the idea is they're going to use your existing financials as the base, right, that that were already audited, and then they talk about how they're going to treat certain of these events, and they would then augment the financials that they've got on file and treat whatever that intervening event is as they indicate they're going to, and do a recalculation. So yes, it is my impression, they're not going to ask you to get a new set of audited financials. I think what they're going to do is take the most recent set of audited financials they have for you and then augment them and do a new projected composite score taking into account that event. And again, the regs talk a little bit about how they think that they would do that depending on the nature of the event that occurred. Great question. So I think we're talking about here under the discretionary events. It says, does state agency also include state boards of nursing, which is separate from the licensing authority? Great question. The department actually, I think, talks a little bit about this in that June 3rd and June 19th guidance that they've put out. And my take on that guidance and where the department's landing right now is I think they're really focused on state authorizing entities for the most part. But if you have a situation where the only program you offer, for example, is a program that is, if you're a single program school, so if you're just offering a nursing program so that the State Board of Nursing's approval is essentially an institutional level approval, I think that changes the calculation. Because where I've seen this question is people have asked about on the accrediting side, what if it's a programmatic accreditor? And the department has said, well, if the only program you offer at that location or institution, is programmatically accredited, and this would put you out of business, then it becomes an institution level concern, right? So I think that's how they're trying to sort of draw that line, but I would look for additional guidance on a go-forward basis from them as well. For students who have not re-enrolled within the 3 years after a school closes, do the students have to have been paying the loan, request the loan be deferred? So if a school closed and you were enrolled at the time the school closed so that you qualify for the closed school loan discharge, you couldn't finish your program, you could immediately apply for a loan discharge, right? So you don't have to wait 3 years. You don't have to pay on the loan, right? I mean, the day after. In fact, you could even withdraw before this. Theoretically, a student, if they're in that 120-day window, as soon as the school announces that it wants to close, assuming the student understood all this and how this works, theoretically they could just withdraw, right? I mean, because they were enrolled within that 120 days of the school's last date of instruction. They don't have to wait, and they could file a closed school loan discharge application. So they don't have to pay the loan. Now, theoretically, under the rule, if the student then goes and transfers their credit to another institution, or they participate in a teach out at another institution and complete their program, or they transfer their credits, right, then they're no longer supposed to qualify for the closed school loan discharge. And when they apply, or if they were to apply, I mean, under penalty of perjury, they have to say, you know, did you transfer your credits, or et cetera. But the department, I mean, aside from their representation, there's no system for tracking any of that, and that's part of my concern is, you know, and I've stated this openly at negotiated rulemaking. I mean, I was actually involved in a closed school situation where I was speaking to a large group of students, and I don't want to sound overly cynical. By the way, I mean, just again, let me state for the record, if a student is unable to complete their program because the school closes, and they don't want to participate in the teach out, there's no teach out available, et cetera, you know, I mean, the law clearly states, the statute, that they are qualified for a closed school loan discharge, right? So I don't want to make any bones about that. Again, my concern is about the inability of the agencies right now to track whether or not folks are really qualified for the closed school loan discharge. And I had a student, so I was announcing a school closure to a large group of students. And within the first 10 minutes, 15 minutes, I mean, I only spoke to him 25, 30 minutes, and most of that was answering questions. But I had a student who raised his hand, and he said, help me understand this, because I also told him about their closed school loan discharge obligation, which I always do if I'm involved in a school closure, and I think is the right thing to do. So I explained how it worked, and the student said, well, okay, so if I apply for a closed school loan discharge, because we already knew this, when the school was going to close, and it was, you know, the school, all the students in that room were within the 120-day window. He said, so if I apply today for a closed school loan discharge application, he said, what's to keep me, after I get the discharge, from then turning around and taking my transcript and enrolling in another school? I mean, at the time I make the application, it's true that I haven't transferred my credits. And I had no answer for him. I just said, well, that's between you and the Department of Education, right? But that's sort of the problem right now. But getting back to your question, if a student who has, you know, if they haven't re-enrolled within 3 years after the school closes, I mean, they could have discharged their loan at any point in that time if they're qualified. You know, this is just about the automatic discharge. So, you know, I guess if their school closes and they don't apply over the next 3 years for closed school loan discharge. And remember, the servicer is going to send them an application. The department's going to reach out to them. There's going to be an effort to let them know, and the school should let them know that they're qualified. So they should have had opportunity to know. Folks are going to be trying to reach out to them and let them know that they're eligible for closed school loan discharge. But theoretically, if a student was eligible but did not apply and the 3 years went by, they would pay on the loan in the interim until they got the automatic discharge, because they haven't applied for a closed school loan discharge, and that's assuming they haven't re-enrolled, right? Sorry, I know that's complicated. I feel like I was kind of all over the place. I hope that was helpful. Last question. Does a statement in your catalog regarding a criminal record prevent you from obtaining a professional license? Exempt the institution from a false claim based on criminal record. Well, I mean, these are two. Oh, I see. So if there's a statement in the catalog saying that having a criminal record may prevent you from obtaining a professional license, I mean, I think that's a good idea, by the way. I mean, you should be letting students know, obviously, and I would go beyond a statement in a catalog. I mean, I would let all of my students know, and frankly have them sign a disclosure in advance, that if they're entering some type of program where they won't be able to get employed on the other side if they have a criminal record, I would want them to know that right up front, and I would want them to sign something saying that they know it. I mean, part of that's for the institution, and part of it's for the borrower and the student, because they may not know that. And it should be very clear to them, you know, that the profession you're looking to enter into, if you've got a criminal record. The other reason it's really important to do that, by the way, is because sometimes, theoretically, a student can come into a criminal record while they're in the program. So someone at the time they enroll may not have a criminal record, But if you didn't disclose to them that that's a problem, then if they get halfway through and suddenly they have a criminal record, they may not know at that point that it's et cetera. So it's always a good idea on the front end to make sure that you're disclosing to your students any requirement along those lines, right? If they can't have a criminal record, if that's going to prevent them from getting employed, physical issue, requirements for folks to get employed in that profession. I mean, you want to be giving them a lot of good information. You don't have to ask them if they have a criminal record. In fact, I think it's better to sort of just say, look, we're not asking you, although it could prompt the conversation, but I think it's better to just disclose and say, look, these are all things you should know before you enter into the program so that you're aware that these would be problems if you have a record, if you have certain types of other issues, et cetera. But giving them that disclosure is not the key. That's not what guards you from a false certification discharge. What guards you from the false certification discharge is the fact that you, the school, didn't know. So whether you give them a disclosure or don't give them a disclosure, either way, the key question is, did the school know? If you give them the disclosure, I think it is likely to prompt a conversation if they do have a criminal record, in which case now you have that knowledge and you can avoid certifying the loan, right? And by the way, there's a distinction here. I mean, if someone came to you and said, I have a criminal record, I saw the disclosure, you might say, well, we can still educate you in the program, but you should understand that if you have a criminal record, we can't certify you for a loan, and you may not be able to practice in the profession in this state. And I've had at least one instance where a student said, you know what, it's okay. I'm really taking it primarily for my own edification. I'm not that concerned, and I can pay cash. All right, and so the school still had them sign a disclosure to that effect, but they were still able to enroll them. What you can't do is you can't certify them for the loan if you have that knowledge, and it would prevent them, from meeting a state requirement to get into the profession. All right, guys, so that's everything. Thanks so much, particularly those of you who may have stuck in for 2 days, 3 hours of information about this rule. You're braver than I am, in a sense. Hope you enjoyed it, and if you have questions about the rule, reach out to your counsel or your accountants, or you can give us a call, and we would be happy to help. Have a great week, everyone, and hopefully we'll see you next month for mergers and acquisitions.